Hi, my name is Eric Willison. I'm an Ohio attorney. I've been practicing in landlord-tenant law since 1996. The important word there is Ohio landlord-tenant law. The laws of the states of the United States are different and the same in many ways, but I wouldn't know because I'm only certified to practice in Ohio. So if you're in Alabama and you're looking for legal advice, you come to the wrong place, brother. So, another thing too is about this issue of legal advice. This is for educational purposes. I am an attorney, but I'm not your attorney. I've never met you. You've never paid me anything. But most of all, I don't know the specific facts of your case. So you would be very unwise to think of this as legal advice. Instead, you need to think of this as legal education. Now, in a previous video, we talked about the three types of defenses that tenants will have to evictions. One would be the merits defenses. Landlord says, you did A, and the tenant says, no, I didn't. Then there's the legal defenses, and then there are what are called the procedural defenses. Now, let's get into a legal defense. In Ohio, the eviction statute for residential landlords and tenants is 1923.04, and it says that before an eviction can be filed with the court, the landlord must first put a 3-day notice to vacate on the door. Now, that 3-day notice to vacate has to have certain statutorily mandated language in it. And that wording is in quotes within the statute. And if you don't get that wording into your 3-day notice and get it word perfect, no misspellings, no missing punctuation, no missing words, it has to be in there word for word. It doesn't matter if you just left out a preposition and everybody knows what it meant, Your Honor. No. Word for word, or you're done. That's because the 3-day notice is jurisdictional. The court does not have the power to hear an eviction case over residential landlords and tenants if those words are not in the 3-day notice. So, if you don't have the words in there, you're done. Secondly, about these words have to be eye-catching. They have to be emphasized. They have to stand out from the rest of the 3-day notice. They can't just be in all the same type, sort of buried in the boilerplate. So when I do a 3-day notice, I enlarge those words, the fonts of those words, from a 12 point maybe up to a 16 point. And I put them in all caps, and I put them in bold, and I put them in italics, and I underline them. And then I might even take a fluorescent marker and put a little arrow pointing to those words. Now they stand out from the rest of the 3-day notice. If they don't stand out, if they're just sort of buried in there with everything else, or if something else stands out more, like you got a big red letters 3-day notice to vacate at the top that's like this big, but then your words are just in black and they're smaller, and yeah, maybe they're in bold. Well, does that really stand out enough? Now you got a problem. You may win, but now the tenant's got an argument, and we don't know how the judge is going to go for that argument. The judge might go for it. The judge might not like the way you bought your eviction. Gee, the tenant had been a tenant of yours for 3 years and had never missed a rental payment and always been on time, but they got back late from their vacation by 1 day, and now you want to toss them? Well, you know what? I don't think you got your 3-day right. Case dismissed. So that could be what happens. So you got to be careful about this kind of stuff. Get your wording right, and you got to get it and make it eye-catching. So that's one of the legal defenses that you're going to have for an eviction.